Hello, everyone. I'm Leonard French, your favorite copyright attorney, and I'm back in the US and bringing you the 10th Circuit qualified immunity decision in the Kansas City Swatting case. This was the incident where two Call of Duty players got into an argument, and one of them hired Tyler Barriss to falsely report a shooting and kidnapping, except that the intended victim gave a different address, gave his old address, and when the SWAT team showed up at that address, Andrew Finch very curiously came walking out of his front door, looking around, wondering what's going on, and was shot by Justin Rapp, the Wichita officer who is the defendant in this case and whose qualified immunity is at issue. The 10th Circuit does a good job telling the story. Let's see what they have to say. So this is a 4-publication precedential decision. This is Lisa and Dominica Finch, the co-administrators of the estate of Andrew Thomas Finch, deceased. And the defendants are Justin Rapp and the city of Wichita and someone named Benjamin Yonker. Chief Judge Timkovich writes, at 6:10 p.m. on December 28, 2017, a City of Wichita service officer answered a call. The caller stated his mother had struck his father with a gun. The service officer attempted multiple times to connect the caller to 911, but the call dropped repeatedly. 7 minutes later, the caller gave his number to the officer, who passed along the information to the Sedgwick County 911 dispatchers. At 6:18 p.m., a 911 dispatcher contacted the caller. This time, the caller told the dispatcher he had shot his father in the head and was holding his mother and his brother at gunpoint in a closet. He gave the dispatcher an address in a residential Wichita neighborhood. The dispatcher transmitted alerts to officers that the caller had shot his father and was holding his mother and brother at gunpoint. The dispatcher also reported that the caller was threatening to light the house on fire and commit suicide. Unbeknownst to the officers and the dispatcher, the caller was a Los Angeles resident who had no connection to the Wichita address or its residents, one of whom was Andrew Finch. The call was a false swatting call. The caller was a serial swatter, and he made the call on behalf of a Call of Duty player who wanted to retaliate against another player after a virtual altercation in the video game. But none of the video game players actually lived in Wichita. The caller was given a false address, which happened to be for Finch's residence. Finch had no connection to the caller or the online altercation. He was at home with his mother, his sister, his niece, and 2 family friends. As a result of the 911 call, numerous officers rushed to Finch's address, believing there was a barricaded shooter scenario with hostages. By that time, the December sun had set, and it was dark outside. The first officers on the scene parked and approached the east side of the house on foot, walking through the yards between the houses as additional officers arrived on the west side. The 4 officers east of the house could discern other officers to the north and the west of the house and patrol vehicles blocking traffic to the east. Wichita Police Sergeant Benjamin Yonker arrived and parked southwest of the house. He noticed he was the only supervisor present, so he assumed he was in command. Wichita police officers Justin Rapp and Matthew Powell also arrived southwest of the house. Rapp and Powell were members of a special team that regularly responded to high-risk incidents. Rapp carried a rifle, which he was certified to use from a distance of up to 50 yards. Another officer on the scene told Rapp that, based on movement seen in the upstairs window of the residence, someone was performing CPR inside the house. After noticing there were no exits on the west side of the house, Yonker directed Rapp and Powell to follow him to the front door on the north side. Once they were at the north side, Yonker told Rapp to be long cover, since Rapp had a rifle. Rapp had been an officer for 7 years, and he understood his duty as a cover officer was to look out for the safety of everyone in the vicinity. Rapp positioned himself about 40 yards from the entrance of the house. Powell was within an arm's distance on Rapp's right, and Yonker was a little bit farther to the right. Due to the darkness, Rapp could not see the officers on the east side of the residence, who had moved to a location about 45 feet away from the resident's front door. Rapp had only been in his position about 40 seconds when Finch opened his front door. Finch pushed the screen door open and took a step out onto the porch. An officer on the east side of the residence turned his rifle light on and instructed Finch to put up his hands and step off the porch. Jonker yelled, "Show your hands." At the same time, officers to the east of the house shouted other commands. Jonker then yelled, "Walk this way." Officers later testified that they could not understand the commands being given by Jonker at the north side. None of the officers identified themselves as police. Finch stood on the porch. He initially appeared to comply with officers' demands, raising his hands up to about ear level. Officers, including Rapp, could see Finch was not holding anything in his hands. Finch then began to lower his hands. There is conflicting testimony about what happened during the next few seconds. Some officers testified Finch raised his hands and lowered them a second time, while moving them back towards the doorway threshold. One officer testified he saw nothing indicating Finch was a threat to the officers, but he lost sight of Finch once Finch backed up into the doorway. Another officer, also located to the east of the house, testified that Finch moved his hand toward the small of his back and moved back into the doorway. The officer was not sure whether the movement was threatening or just Finch steadying himself. A third officer at the east side believed Finch was reaching for a weapon when he saw Finch put his hands back down. On the north side, an officer saw Finch reach back with his right hand and place it on the front doorknob. Jonker saw Finch lower his hand and then start to raise his hands in response to the commands. But Jonker was primarily focused on officers on the east side, not on Finch. Rapp saw Finch grab the right side of his hoodie and lift it up, making a motion that appeared as if he was drawing a firearm. Rapp thought Finch was not complying with commands and possibly was armed. He testified he thought he saw a gun in Finch's hand. Now, all this testimony will be vindicated or not vindicated by the video that will eventually be shown to the eventual jury, assuming this case gets that far. So let's take a look at that video now and see what we think about it, because I remember having thoughts about this when it first happened.
Show your hands! Walk this way! Walk!
So yeah, there's a point where you can see his hands moving up and down, and that's the point on which the case is going to turn, whether or not Officer Rapp was reasonably justified in anticipating deadly force or a firearm or something from Finch, and therefore he was justified in pulling the trigger. Or would a jury side with Finch, that Finch was no threat and that Rapp acted outside of the required reasonableness? Approximately 10 seconds after Finch first opened the door and stepped onto the porch, Rapp fired a single shot from his rifle, hitting Finch in the chest. Finch fell backwards into the residence where he died within minutes. He was not armed. Shortly after, police realized there had been no hostage situation or murder at the residence. After the shooting, the 911 caller was arrested and charged with involuntary manslaughter and other crimes. He, Tyler Barriss, pled guilty and was sentenced to 240 months in prison. And Shane Gaskill apparently had struck a deal for a diversion program, in other words, not going to prison, except that he violated the diversion deal and pled guilty to one count of wire fraud on May 3rd, 2022. He now faces new charges and 20 years in prison. He is set to be sentenced in July of 2022. Following the protocol for any officer-related shooting, the police department and City of Wichita conducted a criminal investigation in conjunction with the Kansas Bureau of Investigation. The Sedgwick County DA then determined whether criminal charges should be filed against the officers. Following the investigation, the district attorney declined to prosecute Rapp for his actions. Next, the Wichita Police Department's Professional Standards Bureau conducted the administrative investigation. It exonerated Rapp for the shooting. Finch, through his next of kin, filed a 1983 civil rights lawsuit against Rapp, Yonker, and the city of Wichita, bringing an excessive force claim against Rapp, a supervisory claim against Yonker, and a municipal liability claim against the city of Wichita. The defendants moved for summary judgment, and Rapp raised a qualified immunity defense. The district court granted summary judgment on the claims against Yonker and the city of Wichita, so they win, but denied summary judgment and the qualified immunity defense as to Rapp. Rapp filed an interlocutory or immediate appeal in the middle of litigation of the denial of qualified immunity, and Finch appealed the final summary judgment entered in favor of the city of Wichita. Rapp claims a reasonable officer could believe Finch posed a threat of serious physical harm and therefore qualified immunity should apply. But, based on the district court's findings of fact, Finch could not have posed a threat, and Rapp was not entitled to qualified immunity. Finch claims the city of Wichita's investigatory and disciplinary policies following use of force incidents lacked accountability, reflected deliberate indifference, and caused Finch's death, but he failed to support his allegations with any evidence of such a policy. For those reasons and the reasons below, we affirm the district court's rulings. On such an appeal of a denial of qualified immunity, we can only review questions of law, says the appeals court. We are not at liberty to review a district court's factual conclusions. So just to be clear, the 10th Circuit Court of Appeals is not verifying the truth or falsity of the facts that were found by the lower district court. They are acting on the facts that were found, but they are analyzing the law for errors or corrections. At this stage in the proceedings, we cannot review the district court's findings that Finch was unarmed and unthreatening. Instead, we must accept all such inferences as true for the purposes of this interlocutory appeal. We only review the district court's legal conclusions that the facts, in the light most favorable to Finch, establish a clear violation of the Fourth Amendment, and Rapp, therefore, was not entitled to qualified immunity. Qualified immunity involves a two-part inquiry. See the case of Cortez versus McCauley, a 10th Circuit case from 2007. First, the plaintiff must establish the defendant violated a constitutional right. If no constitutional violation is established by the plaintiff's allegations or the record, our inquiry ends. But if a constitutional right was violated, we ask if the constitutional right was clearly established. To be clearly established, a constitutional right must be confirmed by Supreme Court or 10th Circuit precedent or the overwhelming weight of authority from other courts. On this interlocutory appeal of qualified immunity, we can only consider 1, whether the facts that the district court ruled a reasonable jury could find would suffice to show a legal violation, or 2, whether that law was clearly established at the time of the alleged violation. The Fourth Amendment prohibits state and federal governments from making unreasonable seizures. Excessive force claims are analyzed under this Fourth Amendment and its reasonableness standard. And that's citing Graham v. Connor, a 1989 Supreme Court case. That standard asks whether the police employed objectively reasonable force given the totality of the circumstances. This inquiry pays careful attention to the facts and circumstances of each particular case. In Graham, the Supreme Court identified 3 factors a court should consider when evaluating a claim that police officers used excessive force. First, the severity of the crime at issue. Second, whether the suspect poses an immediate threat to the safety of the officers or others. And 3, whether the suspect is actively resisting arrest or attempting to evade arrest by flight. Accepting the district court's factual determinations in the Finch case, as we must, we find that the district court did not err in denying summary judgment in favor of Finch. The district court concluded that a reasonable jury could find that Rapp fired a shot when he could see Finch's hands were empty, or Rapp's assertion that Finch made a threatening motion was false, or that Rapp could not see Finch's movements clearly due to darkness and distance, along with numerous other facts, some of which are Finch was confused but attempted to comply with officers' commands, and his movements did not indicate hostile or threatening action, that persons yelling at Finch were not immediately recognizable as police, that Finch simply moved his arms when officers were giving him multiple commands, that Finch's movements did not suggest he was attempting to draw a firearm, that Finch was never told to keep his hands up in the air or that he would be shot, that an officer could see that Finch was not actively resisting commands, and that Rapp was unaware that Finch was attempting to go back into the house when he was shot. Thus, the court found that a reasonable jury could also conclude that Rapp did not reasonably believe Finch posed a threat. Rapp now argues that we are not bound to accept the district court's determination of what a jury could find, but an appeals court can't deviate from its usual deference and instead review the appeal brand new, except in 3 circumstances. First, if the district court failed to identify the charged conduct it deemed as supported by the record. Or 2, if the district court's account of the facts is blatantly contradicted by the record. Or 3, the reasonable factual inferences arise during the motion to dismiss stage of the case. These exceptions do not apply here. Rapp argues that the district court ignored video evidence that blatantly contradicts the court's findings, item 2 above. But nothing in the video footage offered by Rapp indisputably contradicts the district court's findings that Finch's motions did not reasonably suggest he was attempting to draw a firearm, and Finch did not pose a threat of serious physical harm to others. In the video, we see Finch raise his hands, but there is nothing that could blatantly contradict the conclusion his actions were non-threatening. Rapp also argues that the district court erred by focusing on the testimonies of other officers located at different perspectives than Finch, but the various conflicting testimonies of other officers are relevant to whether a jury could find that Rapp reacted reasonably for an officer in his position. They demonstrate a genuine issue of material fact. Whether Rapp reasonably believed Finch presented any threat is a genuine issue of fact for the jury to determine. On to the clearly established element. Having found a constitutional violation, the district court correctly denied qualified immunity because Rapp's action violated clearly established law. A clearly established right is one that is sufficiently clear that every reasonable official would have understood that what he is doing violates that right. As a result, qualified immunity protects all but the plainly incompetent or those who knowingly violate the law. Although we do not require a case directly on point, existing precedent must have placed the statutory or constitutional question beyond debate. For a law to be clearly established, it must not be defined at too high a level of generality. The rule's contours must be so well defined that it is clear to a reasonable officer that his conduct was unlawful in the situation he confronted. This is especially important in the Fourth Amendment context, where it is sometimes difficult for an officer to determine how the relevant legal doctrine, excessive force here, will apply to the factual situation the officer confronts. In determining whether the law was clearly established, the district court included inferences that Rapp could see Finch did not have a firearm, that Finch did not make any movement like he was drawing a firearm, and that Finch made no motion indicating he was about to shoot. The district court relied on 4 cases to determine that the right not to be subject to deadly force was clearly established. These are Zuckel v. Spinharney, Zia Trust Co. ex rel causi versus Montoya, Walker versus City of Orem, and King v. Hill. Taken together, these cases establish a constitutional right so clearly established that every reasonable official would have understood that what he was doing violates that right. First, in Zuckel v. Spinharney, police approached a man having a confrontation with a group of teenagers. One of the teenagers yelled that the man had a knife as the man turned around and approached the officers. An officer shot the man 4 times. The man had only been holding a pair of fingernail clippers. The court denied qualified immunity. In Zia Trust Company, ex rel causi versus Montoya, police responded to a report of a dispute between a caller and his adult son who had mental health issues. The dispatcher reported that there were firearms at the residence. The officer arrived at the residence and saw the suspect sitting in a van. The man allegedly pointed the wheels of the van at the officer. The officer fired a single shot into the van and killed the suspect. The court affirmed the denial of qualified immunity. In Walker versus City of Orem, Police officers reported to the residence of an individual who they had been told was suicidal and en route to cause harm to his family. It was reported that the suspect was unarmed. When police arrived, the suspect held a box cutter to his own wrist. An officer shot the suspect, and a second officer shot 2 more rounds. The district court denied qualified immunity, finding that the suspect did not pose a threat and was not moving towards anyone. Finally, in King v. Hill, a non-presidential case, officers received a report about a mentally ill man making threats against his spouse. Despite testimony that the man did not have anything in his hands, an officer shot him with a rifle after the man yelled at the officers to get off his property and threatened them. The court relied on Tennessee v. Garner for the established principle that an officer may not seize an unarmed, non-dangerous suspect by shooting him dead. In the most factually similar 10th Circuit case, Huff v. Reeves, from 2021, officers responded to a report of a bank robbery where an individual had been shot and the robber had taken a female hostage. After a police chase, the suspect's car stopped. The hostage exited and was shot by police officers while running towards the officers with her hands in the air in a surrendering pose. The court concluded that although there are no cases that address the precise set of facts, shooting the hostage while she posed no threat of harm to the officers violated clear precedent in this circuit. Huff was decided after the events of this case occurred, so it cannot establish that Rapp should have known his conduct was unlawful, but it is instructive as to the analysis of whether Rapp's conduct violated a clearly established right based on our case law. To be sure, there is no case with identical facts to those here, but we do not think it requires a court decision with identical facts to establish clearly that it is unreasonable to use deadly force when the force is totally unnecessary to restrain a suspect or to protect officers, the public, or the suspect himself. Taken together, the cases relied on by the district court establish that an officer, even when responding to a dangerous reported situation, may not shoot an unarmed and unthreatening suspect. A jury could find that Rapp shot Finch even when a reasonable officer would have known Finch was unarmed and posed no threat. Thus, viewing the facts in the light most favorable to Finch, Rapp violated clearly established law. Then the 10th Circuit affirms the denial of municipal liability. A municipality is not directly liable for the constitutional torts of its employees, but the city may be held liable under the Monell Doctrine if it executes an unconstitutional policy or custom, or a facially constitutional policy that causes a constitutional violation. Here, Finch alleges no unconstitutional policy or custom, so we ask if the policies he does allege caused a constitutional violation. To prove such a Monell claim, a plaintiff must first show a municipal policy or custom, either an official rule or one so entrenched in practice as to constitute an official policy. Next, a plaintiff must show that the municipality was deliberately indifferent to constitutional violations that were the obvious consequence of this policy. To demonstrate that a municipality acted with deliberate indifference, the plaintiff must show the municipality had actual or constructive notice that its action or failure to act was substantially certain to result in a constitutional violation. So there's a substantially certain standard there. And consciously or deliberately chose to disregard the risk of harm. Notice can be established through a pattern of tortious conduct, or if a violation of federal rights is a highly predictable or plainly obvious consequence of a municipality's action or inaction. Finally, a plaintiff must show that the policy directly caused his constitutional injury. A plaintiff can establish a direct causal link only by showing that the municipal practice was closely related to the deprivation of rights. Finch claims that the city is liable for 2 widespread Wichita Police Department practices that amount to official policy. First, he alleges that the department's investigatory and disciplinary practices were so meager that they amounted to a policy of inaction in response to excessive force incidents. His evidence shows a policy of light discipline, reprimands, or one-day suspensions in response to department policy violations generally, not in response to excessive force incidents. Second, he alleges that officers had a practice of using excessive force by shooting unthreatening civilians. But most of the evidence Finch presents is not relevant to the alleged policy of excessive force. First, Finch claims that the city's investigative and disciplinary process following use of force incidents is inadequate. He especially takes issue with the department's use of interviews and evidence conducted by the district attorney's office. This reuse means the department rarely conducts its own interviews. Further, the department sometimes relies on the already gathered evidence to make credibility determinations or resolve conflicting narratives. Finch argues that this practice makes the investigatory process less reliable and that this policy of inadequate investigation and discipline caused his shooting. The city's process is as follows. After a police-involved shooting, the city performs a criminal investigation coordinated with the Kansas Bureau of Investigation. The DA observes the investigation, considers the evidence, and independently decides whether to file charges against an officer. After the criminal investigation, the Wichita Police Department's Professional Standards Bureau conducts an administrative investigation to determine whether department policy was violated and whether internal discipline is appropriate. The Professional Standards Bureau uses the evidence gathered in the criminal investigation unless external evidence is necessary. Thus, it often does not conduct its own interviews, instead reviewing the documents and interviews conducted during the criminal investigation. The department then imposes necessary discipline, generally reprimand, suspension, or termination. Second, Finch alleges that police department officers had a custom of shooting unthreatening suspects. In support, he cites police-involved shootings that occurred over the 6 years preceding the incident with Finch. But Finch does not argue that all of the more than 20 shootings he cites constituted excessive force. Instead, he points only to a handful of police-involved shootings that a jury could conclude were unconstitutional. These alleged constitutional violations have widely varying facts and lack a common theme or pattern. Some do not involve excessive force. Even assuming the subset of cases drawn from the 6-year period were constitutional violations, they are isolated when considered in the circumstances presented in this case. Third, even if Finch successfully alleged that the department had a policy or custom of inadequate investigation and discipline, he still could not prove causation. Finch cannot meet the rigorous standards of culpability and causation necessary to prove a municipal liability claim. At best, he alleges the city had policies of 1. Reusing evidence from its criminal investigations in its administrative investigations, and 2. Imposing relatively minor discipline in response to department policy violations. Neither policy would directly result in a constitutional violation in the swatting incident we address in this appeal. To defeat this conclusion, Finch argues that a failure to investigate or reprimand might cause a future violation by sending a message to officers that such behavior is tolerated. But he did not explain how a failure to respond to minor policy violations could send a message that dissimilar conduct, like the use of lethal force in this case, is tolerated. Thus, his arguments do not meet the demanding standard of causation that we require in Monell cases, namely, the direct causal link between the municipal action and the deprivation of federal rights. In sum, Finch has failed to show any deliberately indifferent policies or customs that caused Rapp to use excessive lethal force. Because he has failed to provide any evidence of a viable municipal liability claim, we affirm the district court's granting of summary judgment for the city. So what happens next is either an appeal up to the Supreme Court, or the case will go back down to the district court level for its trial or further adjudication on summary judgment. If there's any issues left to be resolved in summary judgment, probably not. So it looks like it's going to either be settled or go to a trial where a jury will hear all of the evidence and a judge will determine what evidence is admissible and what evidence is not. And then a jury will have to decide whether Finch's movements were something that could justify a reasonable officer's firing of a bullet and killing Andrew Finch. Or maybe the jury will determine that it was not reasonable for an officer to shoot Mr. Finch in those circumstances. Personally, that's a tough question for me. I saw the video. I can understand the argument that moving the hands could be drawing a firearm. But I'm also thinking of poor Mr. Finch's state of mind when he sees a whole bunch of police cars roll up on his family property, just outside, and he's like, oh, wow, look, flashing lights. I want to go outside and see what that is. What happened outside? Was there a car collision? What happened? And he doesn't realize that he's the target, or that house is the target. He doesn't realize that they're there for him. So he goes out and he's like, hey, what's going on, guys? And then when he hears officers shouting at him and there's lights flashing and it's dark outside and apparently people couldn't hear, even the officers said they couldn't hear each other from across the property. So maybe Mr. Finch was confused by the confusing situation. In the process, Justin Rapp shot him. So I do have a lot of sympathy and even empathy for the parties here. Justin Rapp, I don't believe, was trying to be the defendant in this case. I certainly don't think that Mr. Finch was intending to get shot. So this is a really shitty situation that is brought on by the Shane Gaskill and Tyler Barriss and whoever that third person was that decided to call in a SWAT incident, and that got Mr. Andrew Finch killed. So I will keep an eye on the sentence for Mr. Gaskill, and I think there was a third person there. And I'll make a follow-up video in a few weeks, and we'll keep an eye on what goes on with this case. Hopefully this has a deterrent effect on others who call in swatting incidents, and hopefully it also has sort of a training effect, an awareness effect for officers who might be sent on a false swatting call. Let me know what you think in the comments below. Thanks for watching. Special thanks to my top supporters in the month of July: John Steele, Eevi, Spirit Bear, Benjamin Hitov, Ugly Grill, Torpedan, ShadowTycho, Gutbrodj, PureMagma, Eric Tams, TechTechPotato, The Blood-Soaked Survivors, Wyatt Calandro, and King Aries. You can support Lawful Masses on patreon.com/ljfrench, sponsors.com/law, through YouTube memberships, and through Floatplane subscriptions. Join me for my weekly live production stream on twitch.tv/lawfulmasses on Sunday mornings at 10 a.m. Eastern US time. I hope everyone has a great week. I love you all.